Our topic for today is entitled Law Enforcement Unleashed, State and Local Responses to the Federal Government's New Policing Agenda. As I hope you can tell from this title, our aim was to explore a few related and extremely timely and challenging topics. All of these revolve around dramatic changes that have taken place in the federal government's current approach to criminal law enforcement in the second Trump administration. This is itself a vast topic, and there are many major aspects of it that could well benefit from separate full panel discussions, and some of them will as the semester goes forward. I'm thinking, for example, of the recent U.S. military strike on an alleged drug transport vehicle off the coast of Venezuela, of the very recent and quite striking Supreme Court decision to permit racial and ethnic profiling in immigration and criminal enforcement, and the deployment of U.S. military forces to the streets of Washington, D.C., Chicago, California, and yes, Boston now. So this is all quite serious, what's happening, and I'm really happy to see such a large turnout because these are very compelling issues and we need to talk about them seriously. We will consider today state and local responses both to such extreme federal interventions and to a parallel set of phenomena which I would call federal abdication of oversight against various types of police practices. And by abdication, I'm thinking of how, for example, very early in the second Trump administration, the Department of Justice froze quote-unquote pattern and practice investigations, abandoned consent decrees, deleted the National Law Enforcement Accountability Database, and withdrew technical assistance and funding for police training and community safety programs around the country. We see these phenomena as deeply connected. This is what we sought to capture by using terms like unleashed and new policing agenda. We don't know exactly what that agenda is, but we're seeing features of it that are starting to emerge. There's clearly much to discuss, and luckily we have assembled for you an absolutely stellar panel offering a wide range of perspectives on these issues. So as my final introductory act, let me very briefly introduce our moderator, who will frame our discussion, and our panelists, who will then also very briefly introduce themselves. We could have taken the whole panel just going through their bios, so look that up, we have access to that, but they modestly agreed to keep that brief. Our moderator is Michelle Leung, who is the inaugural clinical instructor of the Race and Law Clinic and a lecturer at Harvard Law School. Previously, she served for over 10 years as an assistant U.S. attorney in the Civil Rights Unit in the District of Massachusetts, where her practice focused on police misconduct, prison conditions, and discrimination matters. She also has served as an assistant attorney general in the Civil Rights Division of the Massachusetts Attorney General's Office and as a trial attorney in the Special Litigation section of the DOJ Civil Rights Division. So I'm going to turn it over to her now and then ask you to just welcome her to Boston College. Thank you.
Thank you all for that introduction, and thank you all for being here for this great conversation. To start the panel, I'm going to let each of our panelists take about 45 seconds to introduce themselves because there's no way I could do justice to all of their incredible backgrounds. So why don't I start at the end of the table? Matt, can we start with you?
Thank you, Michelle. Hi, everybody. My name is Matt Segal. I am presently co-director of the National ACLU's State Supreme Court Initiative, which was a thing launched in 2023 to litigate civil rights and civil liberties in state courts. I also am a professor of practice at Tufts University, where I teach federal and state constitutional law, and so I practice what I teach, which is state con law. Before then, I'll just say briefly that I was, for over a decade, legal director at the ACLU in Massachusetts, and one reason I mention that is that my boss there was your incoming fellow, Carol Rose, who's executive director there, and she's amazing, and if you have an opportunity to attend events with her during her fellowship year, I would strongly urge you to do that.
Hello. Hi everyone, I'm really delighted to be here. My name is Lizz Matos, and I am Chief of the Civil Rights Division of the Attorney General's Office and a Senior Advisor to the AG. That's the Massachusetts Attorney General's Office, just to be really clear about that. And prior to joining the office in 2023, I was the Executive Director of Prisoners Legal Services, which is a nonprofit organization here in Massachusetts that does civil rights work on behalf of incarcerated people across the state. And I was a staff attorney there for a number of years, and then I also did other legal services work in the immigration, primarily immigration, human rights, and housing, and then education as well was a focus for 5 years prior to that. And in the Civil Rights Division of the Police Accountability Unit, and so I'll be talking a little bit more about that in a little bit.
My name is Margaret Hinkle. Since the creation of the Post Commission 4.5 years ago in Massachusetts, I have served as its chair. Among the things I did before I became chair of the Post Commission was to serve for 18 years as a Massachusetts Superior Court judge. I also, for 4 years, was an assistant U.S. attorney in the District of Massachusetts. Lastly, about 1,000 years ago, I was here at Boston Law School.
Good afternoon, everyone. Excuse me. My name is Ronald Davis. I am the former director of the United States Marshals Service, and before that, I was the former director of the United States Department of Justice, a place called the Cops Office, Keeping Anywhere in Policing Services. During that period of time, I had the honor of serving executive director of President Obama's Task Force on 21st Century Policing. Before going into the federal government, I spent close to 30 years in local, 20 years in the beautiful city of Oakland, and I've Oakland to become police chief for about 8 or 9 years in the equally beautiful city of East Palo Alto. So it's good to be here. Thank you.
Thank you, everyone. And I know we'll hear a little bit more about everyone's backgrounds as we get into the panel and start answering some of the questions. So to sort of set the stage and provide some foundation for today's panel, I wanted to step out of my moderator role and talk a little bit about what the federal government's traditional approach has been to advancing police reform and to enforcing statutes related to police misconduct. So since the early 90s, the federal government, via the Department of Justice's Civil Rights Division, and more recently with the help of local U.S. attorneys' offices across the country, has been the agency charged with conducting what we call, quote, pattern or practice investigations, which is a term of art that I think has become more and more sort of well-known and commonplace in news articles. But what a pattern or practice investigation is a systemic investigation that looks at the conduct of generally an entire law enforcement agency. So that's a very distinct sort of role from, say, a private plaintiff, filing an individual complaint about an individual incident alleging a more narrow incident of misconduct. So the federal government has historically used its resources to investigate much bigger systems of alleged misconduct. And these investigations are very labor-intensive, very time-intensive, and after this investigation, historically DOJ has issued findings reports and the goal of those reports is to really make transparent and put down on paper what the investigations uncovered, if they did in fact uncover a finding of some sort of systemic misconduct. And sometimes the investigations did not lead to a finding, but the reports would also indicate why. And it was really a measure of sort of transparency to let the public know sort of what the investigations behind closed doors found. If there was a finding of this misconduct, DOJ had many tools sort of available to remedy that misconduct. There's always traditional litigation as a method of trying to remedy systemic misconduct. But DOJ more regularly would enter consent decrees with those law enforcement agencies in the jurisdictions where they're based. And consent decree, another term of art, which I'm sure you all are familiar with, but in case you aren't, is generally a settlement agreement that's filed in federal court and enforced by a federal judge. So it's just a settlement agreement with an incredible amount of teeth to it. And those agreements are very detailed documents, oftentimes totaling hundreds of pages with hundreds of provisions that sort of are meant to lay out a very concrete, tangible blueprint for reform. So that's just at a very high level what the federal government's role typically has been in advancing police reform, and I wanted to just quickly talk about some of the advantages and disadvantages that folks generally think about when they think about DOJ's role in that police misconduct landscape. First, one of the advantages is that DOJ has a lot of resources. So there are a few other agencies or organizations or individuals who can bring to bear the type of resources that DOJ does when they investigate these agencies. They bring all sorts of subject matter experts to the table. So I work with Ron in this capacity, so we benefited from incredibly talented, retired police chiefs who understood the day-to-day operations of law enforcement and could help sort of parse out incident reports and investigations. DOJ had the resources to retain statisticians who could marshal and analyze a huge swath of data, which was incredibly useful to understanding what was going on in an agency more broadly. And again, there are a few other kinds of organizations who can do that. So that was one advantage. The second advantage, I think, to DOJ's role in this landscape is the consent decree remedy. It's an incredibly powerful remedy where the parties are not just accountable to each other, but a federal court, usually a court-appointed monitor, and with lots of provisions in a decree that allow for transparency, so reporting out to the public about what kinds of reforms an agency is taking to implement the agreement. And I think historically there are also limitations to DOJ's role in conducting these investigations and overseeing the implementation of the decrees. And to go over just a couple of them, I think one, a common critique is that DOJ's agreements are onerous and expensive. So while those hundreds of provisions are meant to, really provide a concrete blueprint for how a department can remedy itself, and that a lot of negotiation goes into making sure an agency knows what DOJ thinks it must do to remedy the misconduct, it can also take many, many years to implement an agreement, and it becomes very costly. Monitoring teams, are sometimes can be large and do engage in a lot of work to help the parties with the implementation of the agreement, and a critique can be that resources that a city could spend on the actual reforms aren't going to the monitoring team. I think DOJ has worked over the years at trying to think through those difficult issues, but that's one common critique. And a second, I think, critique is that DOJ, since the inception of the pattern or practice statute, hasn't investigated that many law enforcement agencies relative to how many law enforcement agencies there are nationwide. I think, I could be wrong, but I think DOJ has investigated about 71 law enforcement agencies. And there are over 17,000 agencies nationwide. So that's a very small percentage of agencies that they're actually able to work on in a fraction of the number of agencies that they would like to, but given how resource intensive those investigations are, that's a huge limitation. And moreover, DOJ has historically investigated large urban departments, whereas the vast majority of those 17,000 plus law enforcement agencies are not in big cities and have many fewer officers. So that is like a 5,000 foot overview, just sort of to set the stage about what the federal government's role was and sort of now what, and that will set the stage for other folks to talk about what roles their agencies are taking in sort of the absence of that role. But before we do that, I want to turn the mic over to Ron Davis, who also played a different and complementary role in the federal government in terms of advancing police reform. Ron, can you tell us about COP's work and the advantages and disadvantages of its work there?
So before I get to that, I want to kind of start with what Michelle mentioned about the 17,000 agencies, and that's critically important because our form of government requires this decentralized model, and that's the idea that local governments, right, have the oversight and responsibility for public safety. Now, considering that 75% of the departments in the United States have fewer than 25 officers, then the role of the federal government really is not about doing mass investigation because there's no capacity to investigate thousands of agencies every year. Those consent decrees become models and become templates. How do I avoid litigation? What are the best practices that I have? And it becomes a kind of a research and development. In order to have a law enforcement capacity or mechanism we have in the United States, Well, not everyone has the research and development capacity of, let's say, New York PD, right? If you got 5 deputies, then how do you do the research and capacity? That should be the role of the federal government, not taking them over, not overseeing them. That should be local. That's the whole purpose of the structure we have. And so the consent decrees were a good foundation, but because we can see they come and go with different executive orders, with different administrations, that can't be where all the bread and butter is at for this concept. So the other part that the Department of Justice used to provide was called collaborative reform. The idea that there's a lot of agencies working with their community that have decided that we need to make change, but we need assistance in doing so. Also equally important is that you're already engaging in activity in which your community is pushing back, which means you lost some trust and legitimacy, that you simply saying, I want to change, is probably not enough. People want to see it actually happen. And so the collaborative reform is a way for the Department of Justice to come in on a voluntary basis, do an assessment of your agency, identify where there are rooms for improvement, where things are broken, what you're doing well, and then come up with a series of recommendations that will be similar to one would be inside the consent decree, and also with an independent monitor, so that the independent objective view of whether or not you're living up to the agreement stands a little bit more trust and legitimacy. We thought this was powerful because, in this sense, you're not accountable to a court, a court of law, but you are accountable to the public court of opinion in that sense. And in many ways, I think moving forward, I will end with this part moving forward. I think the key for communities is not to over-rely on the federal government to that sense. I think as administrations come, as we basically still stand against and use litigation to hold even the federal government accountable, communities starting at the state, and I think we're going to hear about state posts and at the local level, has to start building the capacity so that it does not matter what happens in DC. If a community, whether it's Boston or Newton, says we want to go this way towards 21st century policing, we want constitutional policing, you would hope the federal government would be there to assist you with best practices, research, evidence-based strategies, but if they're not, then build the capacity within it. One of the things that's missing, and I hope a lot of you will take this on as you take on your professional careers, is our law enforcement system is probably one of the most unique in the world in very, very many ways. Now, that's a good note because we don't have a federal police, although sometimes it seems like we're trying to lean that way. We don't have a federal police department. We have federal agencies that are very much siloed in the things that they do. The Marshals Service has specific statutory authority, DEA, FBI, ATF. None of them are so broad that they're meant to basically become a federal law enforcement, a federal police department. But one of the things I think we're going to have to work on is our industry, because it is 17,000 individual agencies, doesn't have a national coherent body of standards, right? As an attorney, if you do certain things, you can be disbarred. If you're a doctor, you don't do certain things based on evidence and science, you lose your medical license. I can be about as incompetent as I want to be as a police chief, and if I'm not fired by my mayor, there is no accountability. And we need to change that part to where that I should be held to the same body of standards as any other profession. Otherwise, in my opinion, we're going to relegate ourselves, not a negative thing, to being a vocation, but not as a profession held to standards that are based on evidence and science. So I think litigation helps with that. Consent decrees set a table for that, but also is going to be coming from you and from the community as well.
Thank you, Ron. Thank you, Ron. And now that we've sort of set the table, understanding what the federal government's traditional role has been in the police reform space, I want to turn it over to some of our other panelists to talk about what state and local approaches exist to address the same reform in light of the abdication of the federal government's role in the space. And Matt, can I start with you to talk about some litigation-based strategies that you all are using at the ACLU to work on this issue?
Sure. I like how Ron put it. We're helping, and the way we help is by suing people. Not everyone that we sue shares Ron's, I think, quite enlightened perspective on what it means to be sued, but that's really how we see it. One thing I want to focus on today is maybe not the most obvious thing, which is suing the police or going after the police for wrongdoing, for reform. There's certainly a place for that. That happens a lot. It's great. But one reason why I am guessing that you are here, in addition to lunch, is a sense that maybe things are not going well. The federal government is not going in the direction we want, and that's not only frustrating, it can, when you're a law student, make you wonder what to be optimistic about. And so one of the things that we've done at the ACLU, both when I was at the ACLU of Massachusetts and now at the National ACLU, is to think about what tools in the toolbox are available that maybe are being underused. And so one of those tools is, in my view, is the set of obligations that fall on prosecutors when members of their teams commit misconduct. So often our debate is about what should the police do, what can the police do, what will the police do to reform themselves or to be reformed by others through litigation or otherwise. But actually, there's this set of laws that already makes somebody responsible when police and other members of prosecution teams commit misconduct, which is what we call the Brady Rule, the obligation to disclose exculpatory evidence. So if you hear in the news a revelation of a police officer committing misconduct, and you think, well, I hope somebody does something about that. I mean, in my view, the law already makes someone responsible for doing about that, and that is any prosecutor who is using or who has ever used that prosecutor, that police officer, to secure a criminal conviction. And so, I can talk about a little bit more, but so what we've done over time is we've brought a series of cases that in the wake of misconduct by members of the prosecution team have picked up the burden of that misconduct from the wrongfully convicted people or from the people who are harmed by misconduct and sought to place it on the prosecutors who use those people to secure wrongful convictions. So we did a series of cases following the drug lab scandals that occurred in Massachusetts, which involved chemists who committed misconduct that tainted cases. And as part of that litigation, we secured what we think is the largest reversal of wrongful convictions in U.S. history. That was through litigation. But it turns out that chemists are not the only members of prosecution teams who sometimes commit misconduct. It sometimes happens with police officers. And so, so the way we looked at these pattern or practice investigations that Michelle was talking about was that if you have a pattern or a practice of police wrongdoing by officers, members of prosecution teams who committed misconduct, yes, it would be good for the federal government to investigate. Yes, it would be good for other people to sue. Yes, it would be good to have a system, as I think we'll hear about, for decertifying offending officers so that they cannot be police officers anymore. But also, it should be the job of the prosecution to identify all of that misconduct, to disclose all the evidence of this misconduct, and to notify all the potentially wrongfully convicted people about this evidence. And this is not only the right thing to do to overturn wrongful convictions, but it can serve as a deterrent. Because if you're a prosecutor and you know that you'll be responsible in the event that you used a police officer who was up to no good, and that this might undo all your work and your convictions, you might want to think twice about associating yourself with police officers who are up to no good. So we did that in a case called Graham in Massachusetts, which resulted in what we think is the first decision of any kind in the state Supreme Court to hold prosecutors responsible for identifying and disclosing the misconduct identified by a federal DOJ pattern or practice report. And particularly now, if the federal government is going to be taking on a different role with respect to police misconduct, less anti, maybe more pro, that it seems to me that state courts and state court litigation are going to be vital tools for addressing this problem, because there are already rules in place, Brady Rule in particular, that make prosecutors responsible for doing something in the wake of police misconduct. And the question is, will those rules be enforced?
Thank you, Matt. That's a good segue to you, Liz. And could you talk a little bit more about your role and the Attorney General's office's role in using state tools to combat police misconduct in this new space era.
Yeah, thanks, Michelle, and thanks, Matt, for excellent points. We wholeheartedly agree. So just to explain where sort of police accountability fits in the Massachusetts Attorney General's office. So under the Civil Rights Division, we have a number of units, and the Police Accountability Unit is one of them. It was launched in 2023, but it is just this week that we have our first director of the Police Accountability Unit, who started, however, is away at a conference this week, otherwise he'd probably be here himself. It's actually someone who has years of experience working with DOJ, doing pattern practice investigations there. Like in Louisville, Baltimore, and a few others. So we're really excited to have him on board and to really continue the work that is already happening. I'll say the Police Accountability Unit was started, I think, it was partially in response to the Police Reform Law of 2020. But there was already police accountability happening within the Civil Rights Division and in the office. And that some of that work is still ongoing, and there are a number of other investigations. I can't talk specifically about them, unfortunately, but I can tell you generally what some of the work is that we're doing and kind of the buckets that they fall in. So the office, in the capacity of the police accountability, within the Police Accountability Unit, gets intakes every week. So we get dozens of intakes every week, a range of issues. A portion of those intakes generally has something to do with policing. They range, however, in the kinds of issues that we receive. Sometimes it's someone who really needs a lawyer to get them damages and whatever action happens. And we refer those out appropriately. Sometimes it's about something like access to records or information, and similarly not something that we would help with. What we're really looking for in those intakes is that particular intake or complaint that was filed indicative of a systemic issue, and are we getting like 10 complaints from Lawrence PD, for example, and like what is going on here is about the same issue, and how are we equipped to really engage. There are also a number of complaints that we receive that we refer to the Post Commission, which you'll hear more about in a little bit, which was also created out of the same Police Reform Law in 2020. Right now, we have a couple of investigations going on in the realm that kind of span. So it's in law enforcement. We're talking about policing here, but we're also in the corrections and the detention space, investigating and this is public knowledge enough that I can at least say it's related to the youth violence strike force of the Boston Police Department. And then another that is relevant to school resource officers that was ongoing prior to the Police Reform Law. So in addition to these investigations, which could lead to litigation, and to kind of writing reports that might expose a particular pattern or practice, we can and really prefer, and we are also doing this right now with a different police department, collaboratively, voluntarily, really working on reviewing policies or practices relevant to a complaint that we received, and going through that and working with an expert to identify not just compliance issues, which we have already identified, but also best practices. What should this look like, and what could we strive for here to really make this as strong as possible and reduce the instances of interaction with the community that are necessary. So that, I think, is a really important role that we could play, kind of technical assistance role in more, again, collaboratively coming up with model policies and practices that can be utilized in other parts of the state. I'd say I think the most important thing, and I know we'll talk about this more a little bit later, is really dedicating resources, which this will be a focus of the planning work that we'll be doing with the new director who's just come on, focusing on community engagement and building real relationships with folks on the ground. We've done that already in the capacity of some of the work that is ongoing, but it is really intensive work, but also fundamental. If we're not doing that work, we can't be relying on complaints people happen to file, right, with our office. We need to be on the ground, we need to be in touch with folks, because the only way we're going to get systemic change and reform is with communities driving the work and helping to shape what the remedies are that they want to see. And so that is, I think, what we're striving for in the office. It is a bigger task than the words coming out of my mouth. It takes a lot of intentionality and time, but I'm really dedicated to that piece in particular.
Thanks so much, Liz. So we've heard from the ACLU and the state AG's office, which are probably entities that folks are more familiar with. But I would love for Judge Hinkle to talk about Post's new role in the police accountability space. Because Post is a relatively new commission and state body that started as a result of the reform bill in 2020.
Thank you. You've already heard from me and from Liz that the Post Commission was created in the wake of criminal justice reform 4.5 years ago. Our mission is to improve policing and to enhance public confidence in law enforcement through a fair process for mandatory certification, mandatory discipline, and mandatory training for all 22,000 police officers in the Commonwealth. The legislature empowered an independent, majority civilian commission to receive complaints and incident reports, to investigate, to adjudicate, and to discipline officers who engaged in misconduct in Massachusetts. Now, we are also directed under the statute, under our enabling statute, to refer patterns of racial profiling or of the mishandling of complaints of unprofessional conduct by agencies to the Attorney General, who may then bring an action to eliminate a particular pattern or practice. Now, at Post, we initially focused on building our agency, on certifying the approximately 22,000 officers, and to bringing individual officers cases for discipline. Post can decertify individual officers, which effectively means that such officers are precluded from working in law enforcement. But the other thing that we can do is we can suspend and we can order retraining, and we have done both during the course of our years of existence. Post also collects and publishes a lot of data on complaints that come from all sources of the Commonwealth, as you can imagine, and any incidents of misconduct that we learn of. And as we continue collecting this information, our staff will begin focusing on trends to bring forward cases in that regard. Our statute also directs us to certify agencies, and as part of that broad mandate, we have begun to research and to discuss agency certification standards, and we intend to implement an audit program. We believe that this agency-level focus has the potential to address issues around patterns and practices that go beyond the discipline of an individual officer.
Great, thanks, Judge Hinkle. Ron, do you mind if I put you on the spot a little bit? So I asked Ron to talk about his work in the federal government as director of cops. But I would love for you to put on your hat as sort of a local chief, and thinking about state and local responses to police reform. What kind of motivations do police departments and local police leaders have to look internally at how to reform departments and reform practices without sort of the concern that the federal government might come investigate?
That's a great question. And I'm put aside maybe an individual chief's personal desire or professional commitment. I think some of the external motivating factors would, one be, and probably the strongest of all, is the community. And that's why, unfortunately, too often, most of the reform follows some type of tragedy or significant harm from the community, where people are now saying enough is enough, you need to make changes. Because when it comes from the community, it does not just impact me as the police chief, it also impacts the elected mayor, the city council, and whether you're a strong mayor, form of government, or a manager council, all of that has impact. So I would say the community. The other role the federal government has played in the past could be that it's incentivized. So when I was at the COPS office, we put out hundreds of millions of dollars in grants So if you want someone to go in a certain direction, you just can't necessarily do a federal mandate, although that seems to be in question today. But you could put $100 million towards it, saying if you would like to try this and look into this, here's a $50 million grant. So there would be financial incentives, there'd be community demands, as well as the idea of the profession. So within law enforcement, we have professional associations. And so as you're getting successful, as you're doing the work that is returning, giving you return on investment, then these associations can then amplify, lift it up, go to our conferences, tell other 16,000 other agencies, look what they did in East Palo Alto, look what they did in Boston, and here's how you do it. Because as a chief, I go to the conference and I want to hear how this works. It sounds good, but we're sometimes in very much denial. That's not me, that's Boston. That's not me, that's Newton. Until it is me, and then it's like, Houston, we have a problem. So, she's afraid. So I basically, if I had a conference and I start seeing some of the productivity, and I want to be at the top of my professional game, I can do that. So I would say financial incentives, community expectations and demands, and professional, I think the desire to be at the top of your professional game. And I think, here's what I would argue, and this is where post is important and the community is important. That means you should hire people that see themselves in the profession that is serving your community. You should hire leaders to make sure that they want to stay contemporary to the issues, best practices, that they're going to keep learning, that they don't keep talking about what I did 20 years ago when I was in Oakland, or 30 years ago. We've evolved way too much of that. You have a new generation coming in that you're a lot more inquisitive, quite frankly, a lot more, your educational standards are higher. It's a better crop. I've been getting in trouble for saying that, but you are. And so because of that, then I think leaders have to allow you to use that experience, that intellectual curiosity to benefit these agencies. And so you can do that by hiring the right people and by holding them accountable to that way.
Thanks, Ron. And I think sort of embedded in what you were saying also is that local law enforcement agencies, and I think I've heard you say this, and I've certainly heard other police chiefs say this, that when, you know, the incentive to do better is that when you have the community's trust, you're ultimately better at carrying out your public safety mission. When the community is willing to engage with you, report things to you, you can carry out the law enforcement agency's mission more effectively.
I would say that's one of the key things to be effective. When I was in Oakland and then in East Palo Alto, beautiful cities, but especially East Palo Alto, one challenge with pretty significant crime and violence. At one point, the city was dubbed the murder capital of the United States. And the key to that is they tried everything over the years. And when I first got there, they wanted me to go try everything over the years. But the main thing being to saturate every single street corner, don't let people move. Sound familiar? And then somehow that would reduce crime and violence. And it doesn't. It will temporarily pause it. It may displace it for a couple of minutes. But it's not long-term solutions. It's when you're engaging with your community in problem solving. You look at the issues that go to the heart and soul of crime and violence, which in many cases are socioeconomic issues and disparities that impact why you have crime in certain neighborhoods and not others. It goes to recognizing that very few people commit crime, but they exact a lot of crime. And so being strategic enough, almost like a surgeon, where you cut that part out without causing damage to any surrounding tissue. You remove that opportunity, and even then, you do so in a constitutional manner, empathetic, and giving people an opportunity to get back to their community, because more than likely, they're going to come back. So what are they coming back to, and what are you prepared to do for them? Those things we see have measurably improved public safety. But because of the fast cycle that we're in, especially elected officials, there's a surge of homicides. I had more people wanted to tell me, even in East Palo Alto, which is at that time 80% of color, just take everyone to jail until I pick up your nephew, your cousin, and a family member. And that's not a good response. This requires staying the course. It requires investment. And so you're going to hear this right now, especially now, when they're talking about everything from National Guard and all this other stuff. Well, look, if you basically turn a community in a corner to a police state, well, of course you're not going to have crime and violence, right? There's a lot of things we can probably achieve if you just threw out the Constitution. That's the easy part. Any fool can do that, right? The idea would be is how to use the constitutional framework that exist and still become successful. That's what you're paying me for, not the idea of taking some untested, no evidence-based, but very convenient, right? Because it sounds good, it feels good. I can see on the news, 150 people went to jail last night. And you're going to be like, wow, right? But you're still not as safe as you should be.
Thanks, Ron. So again, we're talking about state and local approaches to police reform, and one sort of potential state and local actor we're missing from this panel is someone from a community group or an individual civilian. And so I was hoping that folks from the panel might be able to talk about how you involve community members and folks who are not lawyers and not law enforcement officers in this work of police reform. I know Liz and Ron both started touching on this. So Liz, do you want to go first since you started talking about this?
Sure, I guess I'll let we'll talk about, so there's a lot around, community advisory boards or different sort of oversight models that involve community members, and I think a fair amount of debate around the effectiveness there. But I think it's because there's a struggle to figure out what the best way is to have that kind of community oversight. It's also complicated because the community is not homogeneous, right? Different people feel different things about policing, and but those most impacted, I think, are the folks who should be at the table and be talking about how policing has impacted not just their lives, but what we know and what we've seen is that generationally, right? That it impacted their parents' lives, their grandparents' lives, in many cases goes back many generations, and we need to be listening to that because the research also tells us that part of what is problematic about policing is what is culturally ingrained in policing from our history. And if we ignore that, then I don't think we're going to get to sustainable solutions that actually shift the kind of policing that we continue to see in our communities. And despite the great work done by the Department of Justice and the work done by others since 2020 and prior to 2020, there's still a major credibility problem with law enforcement, right? That has not improved all that much. And I think that's the reality that we have to grapple with. Why hasn't it improved? And we have to be really careful in sitting in the seats that we're in to not rely on reports and other consent decrees to come up with the solutions in that particular area in communities. And I've seen a range. I'm actually pretty impressed by Baltimore, and very curious to see how things turn out there, given how their reaction to the calling back of the consent decree there. So I guess that's the main point that I'll start with, and I'm sure we'll talk more, but I think it needs to be localized, and when we talk about the community, we have to realize that we're talking about many different facets of the community, but we should be centering those most impacted.
Matt, do you want to add to that?
Yeah, I agree with everything Liz said. I wanted to supplement that a little bit. I've been doing criminal justice work, police accountability work for a number of years. As far as at the ACLU, I was an assistant federal defender in North Carolina. And over those years, particularly in the ACLU, I've had a number of discussions with community groups about what problems we're seeing, what we want fixed, what's actually meaningful to us. And those are very helpful discussions to educate me as an advocate what I should be saying or not saying or doing or not doing. But also, since we're at law school, just want to put in a plug for clients. I mentioned this, the Graham case, which was the case that we brought. It was on behalf of many people and organizations that secured this ruling that prosecutors have a duty to disclose evidence arising from a pattern or practice report by the DOJ. Well, Graham's a person. And his name's Chris, and he was convicted in a case in Hampden County in which the police did not turn over an exculpatory 911 call which suggested that someone other than him was the man with the gun that he was prosecuted for possessing. So, representing actual human beings is a really valuable and honor and privilege that you get to do if you go to law school. And there's a lot to be said for that, because you will get people, if you want to do this work, who will come to you and say, I represent the community, I know what's best. And maybe they do, or maybe they don't. But when you represent a client, you are grounded in fact and in your ethics to what is best for them. And that is a very useful thing.
And one thing to kind of agree with Matt, the impact it also has, those individual lawsuits, quite frankly, is also how you change individual, I would say, actions within the law enforcement agency. So for example, most agencies have some type of risk management. If they're large, they're probably self-insured in that sense, but there's a risk management part that goes how many payouts you have. If you're smaller, you may have part of a joint powers agreement. We have multiple cities that have, like an insurance company. And like any other insurance company, they don't like paying out. And so when they do their actuarials, they try to figure out what kind of policies you have, practices you have, why you're getting sued. And if not, then your deductible goes very high, your premiums off the chain, and then people start paying attention. Why are we spending so much? It also changes it because people may not know what they're doing, and many times the community may have been led that they have to accept this. I gotta accept this lack of constitutional behavior for my safety, right? There's a few quotes over the years that talk about anyone who's willing to give up their security for their freedom is basically pretty much going to lose both. But one of the things that comes up, and I'm going to put my wife on the spot as an example, is inside police departments. You can argue, you can yell, you can diversify. Sometimes it takes nothing less than an old-fashioned lawsuit to tell the city that they're wrong. And when my wife and I, we've been married for, I'm going to get in trouble, 29 years, right? It's been 29 years. Right? I was 5 at the time, but she was also Oakland PD, and we were pregnant with our, I want to say, our youngest. And at the time, my wife was a lieutenant going for a captain, and the department had got used to and got sued over the years of bringing women into the law enforcement, but now they were talking about bringing women into the senior ranks, and they weren't prepared for that. So through a lawsuit, she courageously took the city on, won, and that behavior will not continue again. And not only will it not continue in Oakland, it won't continue to stay in California, and I'd be surprised if you find it anywhere else in the United States that says you don't get to determine how many kids we're going to have. You definitely get to determine what I do when I'm pregnant, and if you do so, then you're going to pay the price, because that gets attention. You know, you start laying these lawsuits. So I think in this class right here, as I see future attorneys, you have a lot to say, and you're right, those victims, those individuals, they tell the story. When you go to the community, sometimes it's easy to find those, the loudest voices may not always be the most representative voice. So you listen to all of them. But if you can get a class action lawsuit, you can get clients at the table, you can start proposing people and get the real story, in Houston, we're heading in the right direction. So I think there's a significant role at that local level and at that state level to really change the course. And it may just be one agency at a time, it may not have all 16,000, but it will start having that impact.
Thank you, everyone. I love hearing about sort of grounding this work in the voice of individuals who are actually affected in communities, because that's how I think reform stays durable. As we've seen, federal government priorities are going to shift, and it's possible that, it's less possible, but it's possible even at the state level that agency priorities could shift. But it's those folks rooted in the community and the folks who are most affected that are going to make sure that reforms persist even when governments do what they do. But thinking about sort of making durable reform, Judge Hinkle, can you talk to us a little bit about how POST has sort of hardwired processes to ensure accountability in police agencies in Massachusetts?
You know, that's a question which I think necessarily involves having listened to what everybody else has said. You've heard some consistent language, collaboration, for instance, and one of the things that we have tried at POST to do is to involve collaboration on a very fundamental level. We have collaboration, I think, between litigators, policymakers, police leaders, and community advocates, because we know that that's necessary for reform. POST has the ability to issue regulations that govern certain practices, and that govern individual police officers. But our regulatory ability is, however, at times significantly diminished when it comes to some interactions with municipal officers. And that's when we look to other agencies, such as the Attorney General's Office or the Inspector General, if we encounter a situation that necessarily warrants their perspective. In addition, Post leverages the important work of police departments, I think, and their internal affairs investigators. Indeed, a lot of the discipline that is imparted to police officers by the police chiefs we have found is sufficient, and it doesn't merit opening an investigation by Post. I think that probably is different from what we commissioners had anticipated at the beginning of Post. 3 of our 9 commissioners are police officers, but the majority, as I've already told you, are civilian commissioners. We've also discovered that discipline imparted by a chief or by the Civil Service Commission does not preclude us from initiating our own preliminary inquiries. And in instances of criminal conduct, of course, we defer to the appropriate authorities, and we don't start a proceeding unless criminal charges are adjudicated and perhaps withdrawn. As we continue building our agency, we're looking to provide recommendations to the legislature to realize efficiencies and to standardize practices, especially if those require additional funding by police departments. We have a monthly meeting, public meeting, and we are often told during our public meeting how important it is, as we are attempting to initiate some of the things that we want to do, to get additional funding for police departments. So that's something that I think is a necessary goal that others could perhaps speak to here. Another area of collaboration is between model policies and standardization of practices. The history and tradition of local control, as Ron has already talked about in policing, is an important factor in the fact that we have 431 police departments who are subject to our legislation. They are vastly different among themselves, as you can all imagine. And we are attempting to adopt regulations which necessarily, with regard to certification, with regard to training, and with regard to decertification, always talking about due process, take into consideration the enormous differences among those 431 police departments.
Thank you, Judge Hinkle. I'm sensing from the rhythm of the audience that folks might have class starting soon, so I wanted to make sure that we have enough time for people to ask questions. Amanda.
Thanks, Michelle. So I get to Vanna White. I think that's like too old of a reference from this movie. Sorry. I'm going to be passing the mic around. I want to first say the panelists have done an amazing job setting the table for this conversation, but now the conversation is really beginning. And I'm inviting all of you to be a part of this conversation, including those folks who are watching online. I'll be monitoring the Q&A. But what we're going to do first is start with students that are here in the space. Who would like to kick things off? Don't be shy.
My question is it Mr. Segal or Segal?
Segal, good.
Segal? Okay, for Mr. Segal. When you were talking about holding prosecutors accountable under the Brady Rule, I was just curious what the mechanics of those lawsuits actually look like. So are you suing the prosecutor? Is the prosecutor the defendant? And then are you mostly focused with the ACLU in sort of overturning the criminal conviction of that phase of the case? Or are these instances where you're actually, the conviction has been overturned and now you're trying to get the client like some sort of civil settlement, and how that plays out?
So that's a great question. The question, hopefully everyone heard, but basically was, what is the actual mechanism we tried to use to litigate when we sued prosecutors? So it can vary based on each state. Here in Massachusetts, we invoked what is called the superintendent's authority of the Massachusetts Supreme Judicial Court, and we brought a lawsuit under a statute that allows lawsuits under that. That's what we did for the drug lab litigation, as well as the Graham case against, and that was against the Hampden County District Attorney's Office, which uses the Springfield police officers who were identified as being part of a pattern of practice of misconduct in a DOJ report. So yes, these were both of these, well, there were multiple lawsuits. They were lawsuits primarily against district attorneys, in which we sought what we call as in the law injunctive and declaratory relief. So in the drug lab cases, yes, we got the actual convictions overturned. In the Graham case, we got an order from the Supreme District Court requiring the DA to turn over to defendants all across the county, with some exceptions, all of the evidence that the DOJ reviewed as part of its pattern of practice report, which was tens of thousands of pages of misconduct evidence. Other people litigated other aspects of this. So there was, after we got the convictions overturned in the drug lab context, other lawyers privately did class action lawsuits in which they secured the return of the fines and fees that had been paid by the wrongfully convicted people, and there were also some other civil lawsuits. But so it takes a village. But our lawsuits have been primarily focused on this injunctive relief. And I want to say also that when you litigate, it can be opportunity not just to get an order from the court, but to learn things if you have a good faith basis for bringing a lawsuit. So when we sued the Hamden DA, we had an inkling of this because we did a pre-lawsuit investigation, but it revealed that in the wake of the DOJ report, it had turned over a grand total of 0 new documents to criminal defendants in the wake of that report of massive misconduct. 0. We also got an opportunity to cross-examine the first assistant district attorney about an incident in which there was a detective in Springfield said, among other things to a suspect, "Welcome to the white man's world." I asked the first assistant district attorney on the witness stand, was that police misconduct? Her answer was no. So these are the kinds of things, in addition to court orders, that you can bring to light in a lawsuit.
Are there any other questions out there?
Hi, thank you. My question is for Mr. Davis. I was wondering if you have seen any movements on a more local police level of a return to that mentality of community policing. I enjoyed hearing your background as a police officer, because we don't get that a lot in these conversations. I know somebody mentioned Baltimore as well. I would just love to hear from you if there's any broad trends that you observed.
I don't want to sound too overly optimistic, but I think one of the things going back probably in 2014, this was following, remember Freddie Gray in Baltimore, since you mentioned Baltimore, with issues in St. Louis and a few others, President Obama put together the task force on 21st century policing. And one of the first tests we had with that task force when it came out would be the administration left and then Trump one came in and it once again pulled away from the consent decrees. What we did see is that many of the agencies still continue forward with those 6 pillars of policing because of what we talked about earlier, the impact of the community. And I didn't say I'm also a partner at 21CP Solutions, so there was a group of members of the President's Task Force that formed the company specifically so we can continue to work and help carry that on. And so there's still a lot of work. Now, whether or not it's large enough, probably not. But you see, especially with a new generation of police executives, I am very optimistic, without being naive, guardedly optimistic, that they want to go in the right direction. My concern would be is not that they want to go there, is that people don't start putting obstacles in front of them, right? And so some of these executive orders now concern me greatly, and I will say this publicly, because even the grants have new language. Now, when I was in charge of grants, there was always, you don't violate federal law, you don't discriminate, there was always a condition of the grant. Now there's conditions of the grant, from my understanding, that says you will comply with all executive orders and presidential memos, right, to get the grant. There's this idea now that if starting with schools, universities, is going into law firms, or cities next. I spent a year as a city manager. If you're telling me that if I engage in dealing with issues of racial profiling, I'm collecting data, I'm evaluating, I'm doing all these things, that somehow that fits this misnomer of DEI, and you want to take away my grant. Well, it's one thing if you take away my COPS grant, whatever. But if you're talking about all grants, yeah, it could be a $100 million public works grant. That could be a housing grant. So now I'm talking to police chiefs that are getting very nervous, the city attorneys are getting nervous, because the impact can be much bigger than what people are thinking. And so I think this is where the strategy has to be, is to remind the federal government, whatever administration, but let's specifically talk about this one, that as director of the Marshals Service, we made over 70,000 apprehensions and 6,000 murder suspects. The only way to accomplish that was local task force officers partnering with us. And we've seen this over the years. If you want to play this game, then my officers will not help you. And without that, there's some 800,000 local police officers and maybe 90 to 100,000 federal. And so I think communities have a lot more power than they had when you see universities push back, when you do the litigation, and courts are starting to start. They're slow, but they're starting to respond. And local police have a lot of power, state police. So I think there's a desire to your long-winded answer, there's a desire to move forward the way you're talking about. But unfortunately, there's a lot of new obstacles that I would say we have to work together to make sure they don't stop progressing.
Hi, so my question is regarding also the holding prosecutors accountable. So we work at Prisoners Legal Services, which you've probably heard of, I feel like, being in Massachusetts. But I guess my question is related to a specific client that I have who, he was wrongfully convicted, but his entire prosecution and the cops and the defense, like every single official involved, like hid evidence in some manner. And that was in 2001. And so he's been in jail all this time for that. And only now, like some federal attorney happened to read his case and is interested in like taking it on. So maybe now there will be some, you know, repercussions or something that happened. But like his prosecution literally got promoted to justices from his case. So I guess my question is, like, in scenarios like that where it seems like the entire team is kind of like, I know it's like, oh, you're supposed to report if another person's doing something wrong, but if the entire team is kind of in cahoots, then how would that be like addressed, I guess, if that makes any sense?
So that's a tough one. I'll say, you know, I can't respond to that specific case. Obviously, not your lawyer, not his lawyer. But I would say, in general, to me, it's a balance of, you know. So first of all, PLS is great. Worked with Liz when she was at PLS, and I would say that structural changes are often necessary. For example, in response to the litigation that I've been talking about, Massachusetts actually changed a rule of criminal procedure to make it more explicit that prosecutors are responsible not just for the documents in their possession, but for the documents in the possession of all members of their team. And I think often making it less personal helps. Like, people want to go after prosecutors individually and so forth, but just to make clear that you are, like, whether you know it or not, you're responsible for the documents possessed by these other people, and they will be imputed to you whether you know about it or not. I'm hoping, at least going forward, can't help 2001, right? Will make it more likely that prosecutors will affirmatively go to members of their team, the police and so on, and say, tell me about this.
So I have one question from online. The question is, now that the federal government has halted investigations, consent decrees, and general oversight, that seems to send a message that there should be no accountability or transparency for law enforcement. How do you propose that we counter that message, not only to agencies and individual officers, but to the communities who have been fighting for long-awaited accountability and transparency for so long?
I might add real quick in there, it's remind these 16,000 agencies and the 800,000 cops who they work for, right? In my 40 years in law enforcement, I rarely worried about DC or anybody in DC. right? If I basically were to violate the Constitution or something there, I got to worry about, to Matt's point, my prosecutor, the DA that's going to charge me, the state attorney general, that will basically, and post that may basically hold me accountable. So remind them is, think back, and I've even heard people say, oh, you know what, when you put, the president said this once, when you put your head down and go ahead and bang in the car door. Well, the president's not going to be able to save you because, one, he can't pardon you for a state crime, and it's going to be that prosecutor that should charge you with that excessive force under the code of authority for that state violation. So, as also, the person that employs them is going to be that city, that county, or that state, which means if I'm the police chief, you violate it, I don't care what DC told you, my policy says different, bye. And you can find employment somewhere else. So just remind them who they work for, but you can't ignore the fact that the tone is different. So I'm not saying be naive, but just remind them who they work for and who the expectations are set for.
Yeah, I completely agree. I think you've heard the theme throughout the panel that has never been the answer. The DOJ oversight has never been the answer. Also, the findings from these investigations, I think Matt has spoken to this as well, are still out there and real. And there's a lot that can be done with that, and that we should be doing with that. But also, it's always been about the work on the local levels. I'll go back to that. Even though we're hearing that messaging coming out of the federal government, it's underscoring what Ron just said, it's about the local accountability piece and bust AG offices that are doing this work to expand the work, about those that aren't doing this work to be doing the work, about making sure we are driving home, these Brady policies and who is looking at that and making sure that everyone is doing what they're supposed to be doing on the ground. So there's a lot more happening within state agencies, but there is a lot more that has been put in place in local police departments as well. I'm also worried about shifts even here in liberal Massachusetts that will happen as a result of the federal rhetoric. But again, I think if the messaging coming out of our states and out of other entities remains strong as to what should be happening, we do have police reform law here in Massachusetts that is controlling in other states too. And we just keep, with that drumbeat and moving forward with the reform work and let, drown out the noise as best we can. It's a lot of noise.
If I could just add my 2 cents worth. Most states now have post commissions. In fact, at the time Massachusetts created its post commission, I think we were about the last, there were only 4 other states at that point that didn't have post commissions. Now, our involvement, the Massachusetts Post Commission involvement with IADLIS, which is the International Association of Directors of Law Enforcement Standards and Trainings, has provided for us a lot of information on best practices, which we have attempted to implement. IADLIS is, in fact, the organization that maintains the National Decertification Index, and it convenes periodically post directors from across the country. And those from our post commission and our staff who have gone to these conferences have felt that that involvement has been very useful in terms of getting best practices. And so perhaps, and maybe Ron can speak to this issue, perhaps, an enhanced use of what IADLIS is suggesting may be one mechanism for countering what's going on at the federal level.
I would say this, Judge, you guys may have been the last couple to do so, but you have a lot in there that a lot of posts don't have, like the decertification. That's massive. So congratulations on that. The index that the judge is talking about is important because this is how you avoid, if I fire an officer, that he or she doesn't get picked up by the next agency, or even worse, by another state that doesn't have any idea. And unfortunately, throughout employment litigation, there's all kinds of agreements, right? Cities want to get rid of this person, so you cut all kinds of agreements. Hey, just go, say goodbye, and your records are sealed. Then they'll bounce to another state and basically so this allows you to pick up and go to the database, and it says, Ron Davis, there's a flag, you should call Oakland PD. And then once you call Oakland PD, they can say, ooh, I would not do that if I were you, right? Or they may do it. So I think that's critical, that database. And IADLIS is also very critical. 17,000 agencies. What we figured out when we were at the COPS office is you can go after 17,000 individual agencies, or 50 posts. And if they're setting the training standards, then let the post then take those training standards, those things that are the best practices, and trickle down to the 441 in Massachusetts, to 470 in California, and watch it basically spread at a rate that is very fast.
So, when I was chief of staff, I would have a tagline that I pride myself that my meetings end on time. So it is 1:30. I still take pride in having my meetings end on time. This is the 10th year of the Rappaport Center here at Boston College Law School. And I can't think of a more appropriate way to celebrate a decade of impact of the Rappaport Distinguished Speakers panel than with this panel. Each of you panelists have in your own way modeled exemplary characteristics of civic leadership. And thank you not only for allowing all of us to learn from you, but also for seeding some ideas that will generate continued conversation and collaboration and innovation and hopefully some meaningful change. I love that on our first panel of the year, we had the highest subscription rate than most of us have ever seen in this room. We had probably half the 1L class, if not more, here. And you're really doing significant work to influence the next generation of public leaders here at BC and beyond. So I'm really grateful for that. Can we first just give them a big round of applause? And I also just, in conclusion, want to share a few other thank yous. I'm really appreciative of the hundreds of people who have chosen to spend their lunch hour here with us, both online or here in person. And I hope you'll join us for the next event in our Distinguished Speakers series. So we've talked today about holding law enforcement accountable. Our next Distinguished Speakers panel is oriented around the problem of how to keep our own profession as lawyers accountable. We'll be convening a panel moderated by Professor Mike Cassidy, on the use of bar discipline as a tool of upholding the rule of law. There can be no more topical topic beyond the one that we just addressed in this room today. And I hope you will all come to that. And last but not least, I hope that this is not just a conversation that you listen to, you think about for 5 minutes, and then you move on. I hope that the ideas that the panelists have shared have moved something within you to do something about this problem, or at least to share the contours of this problem with people that you care about who you think might also want to know. Our hope at the Rappaport is that we're going to generate not just ideas and dialogue, but really generate impact and change. So thank you all for being a part of this, and I hope you have a great rest of your day.